Yeah. So may I request? I think recording may not be a good idea. Would you be recording this session?
Yeah, we record all the sessions to put on IACC
All
website.
right, not a problem, not a problem.
Yeah.
So just want to give you an understanding first, what is the whole background of, the Global Capacity Center? Why is it any different from what has been happening over the years? This has also, the Global Capacity Center has also gone through a series of evolution over the years. From liberalization days from 1990s onwards, we've had multinationals coming into the country. They have largely gotten into contracts. There's been outsourcing. Certain parts of businesses have been outsourced, if not the entire business. Administrative functions from have been outsourced. Keeping in mind, sometimes they've had very smaller teams here tying up with getting into service level contracts with other bigger service providers. Then slowly came the captive centers, and then came the global in-house centers, which were largely also looking at R&D. I would want to pause here and say even the type of work that was coming into India initially has now changed over a period of time. So while offshore outsourcing and all was easy when the work was limited to a certain kind of function of just getting certain deliverables done, over a period of time, from the BPO world to getting to R&D, and now having a value addition, which is what essentially GCCs offer, has been an evolution. And today what we have is what we are talking about currently is the GCCs, where there is a transformational change driven very strongly by digital transformation and innovation, which has led to global companies now looking to make centers which contribute in a meaningful manner, where there is value addition to the entire process. It's no longer just a back office operation, or it's no longer just outsourcing certain services, or it's no longer just restricted to supporting the global operations. Now it has gone beyond with AI and many other transformational changes coming about in the digital world. The role of the GCC has also become very, very unique and very different now. These are extended arms, I would say, and not just back office operations. These are extended arms which are looking to give meaningful growth. They are no longer support, they are growth drivers. And therefore, you will now see the kind of headcounts that are being spoken about, the kind of work profile that is coming to these GCCs. It's in no manner, any less than what the actual global entities are doing elsewhere. And there, the GCC set up in India are doing almost similar work as far as value is concerned. Now, what is the kind of work, what are these global centers usually? What kind of work are being done by them? They could be IT services, they could be engineering services, they could be telecom and media services, human resource services, research.
Purnima ji, can you hear?
I think Purnima ji is offline. Just she's offline, I think.
Maybe she's joining again. We'll wait for a minute. I think she'll join again. 1 minute.
Let's go back. Yeah. So now let's talk about what are the structures. So when a GCC is coming into the country, that GCC is actually now coming into the legal domain that exists in the country. And the structuring, therefore, becomes very important. As you can see on the screen, two structures are given, which is the wholly owned subsidiary and a joint venture. This is usually the form that is adopted by a GCC coming into the country, where an entity is, a wholly owned subsidiary now is formed, and the global company which is going to carry out operations will be operating through that wholly owned subsidiary as its own subsidiary. One very important aspect is that today when GCCs are coming into the country, there is a very strong presence of a facilitator. Earlier, there used to be service level contracts with entities who would be giving the support as far as the work was concerned. It could be during the transition phase or during the setup phase, a smaller operation was there with service level, with agreements with other entities to support them. But now GCCs and companies are looking to form their own wholly owned subsidiary. This usually happens in larger companies. And when they form their own subsidiaries, they still enter into certain agreements, service agreements, etc., with other entities who provide them support. So the facilitator here is largely from a contractual standpoint. And the facilitator usually does not have a stake in the entity. Now, who is the facilitator? Many times there are entities who are working with these foreign companies, the GCCs, the foreign companies who are opening these global centers in the country. And they are facilitating their entry into the country, and are also providing services as may be needed till such time that these companies are on their own and are ready to take their own operations forward. Wholly owned subsidiary, usually the experience is that these are done by entities who have reasonable experience in the country. These are companies who are large, who are willing to take on the compliances, which could be regulatory, which could be, the HR required support, or rather finding the right talent. Many aspects have to be looked at. And companies who are ready with that kind of, bandwidth usually look to make wholly owned subsidiaries. Now, companies which are possibly not looking to get into the wholly owned subsidiary model because A, they are just testing the waters, B, they are more interested in having a facilitator take an equal or larger role because they would like to transition very slowly, they go through the joint venture model. Now, this joint venture model, why is this important? This is where the large, my experience has been, and our firm's experience has been, that joint venture model is the model where a lot of care has to be taken. So when these companies are starting their own global capacity centers in the country, they tie up with facilitators. And those facilitators form entities. Now, these could be a company. This joint venture entity could be a company, or it could be an LLP, a limited liability partnership. When it is a company, the regulatory requirements are different. When it's a limited liability partnership, the regulatory requirements are different. Compliances in the company are different. Compliances in the, yeah, am I audible? Yeah, compliances in the company are different.
Yes, yeah.
Compliances in a company are different. Compliances in a limited liability partnership are different. How do you choose what you want to make? This has to be driven by your long-term, short-term and long-term plans. So the company that is coming into the country to form this center needs to be very clear on their short-term and their long-term vision. And then keeping that short-term and long-term vision, you then do the pros and cons of making a company, or you set up a joint LLP. Now, why do I say short-term, long-term vision? You have to see what drives the agenda forward. Tax. Earlier, with the LLP model, there were some tax benefits, or rather the structuring was dependent, driven by tax. Company was driven by tax, certain other issues like dividend distribution tax, etc. at that point in time. Now all that is also undergoing a change. So what is very important is that you look at both the vehicles that are available and then decide, keeping your short-term and long-term plans in mind. Now, it is very important. These are there in different slides subsequently, but I'm touching upon it now so that the thought process is not lost. Not just tax, you have to also look at the ease of functioning of that JV vehicle when you are running your center in India. So this is now your JV with a facilitator. How is this vehicle running? If it is a company, will you have a larger role? How will the board be comprised? What will the exit options for the facilitator be? After how many years you are looking to exit? In that, if it's a 50-50 partnership, then how will your deadlock, suppose tomorrow if there is a deadlock on the board, you're taking a decision and the facilitator is not agreeing, or vice versa, how will that be taken care of? What will your actual role be? To what extent will you be involved in these initial years when you are together as a JV? What is the contribution that is looked at from the facilitator? There comes the question of LLP. In the LLP, some of these things may be better addressed in the LLP, while in the company you may have certain issues. But then there are certain things in the LLP which may be better addressed in a company. So, for example, exit, when the partner exits from the LLP, what are the rights that continue to exist with such partner under the Act, under the provisions of law, irrespective of what your LLP agreements say? You have to see all that, because there may be certain rights that may continue with such partner. So these are very important things that you need to keep in mind when you are setting up your joint venture entity. The reason why I'm pausing here and delving a lot into this is because the kind of thought that should go into this, I have in my experience seen that is not possibly the case, unless it's a very seasoned company which has really gone out there and taken a lot of advice. This area tends to be a little open, because many times the facilitator is trying to reduce their own risk, and therefore also trying to reduce their own compliances, and may prefer one model as opposed to the other, keeping their agenda in mind. However, as the incoming entity, you have to see your long-term agenda, your short-term interest, your long-term vision. What is it that you will lose out by not having gone through a certain structure as opposed to the structure that you apply, not just in terms of how the business is run, but because it's a facilitator involved, tomorrow there will be a parting of ways. In that parting of ways, what are the complexities that come? What happens to your IP? What happens to the rights of the facilitator? Will they be continuing rights? If they are not, if they are going to be continuing rights, how can they be curtailed? What is the risk benefit analysis? So all those things have to be looked at, and in my experience, there could be some, this is one area where possibly companies don't really put in the kind of thought that should go into, because largely they are driven by the thought process of the facilitator. And then these are, and the facilitators, I must say, are also very seasoned. They also look at the interest of the company. It is not that they don't, but sometimes when you are structuring, then it may be a better idea to also do your own study and then see how the interests of both parties can be married together to ensure that the vehicle that you create, the entry vehicle that you create, is not going to be so problematic as and when you are parting ways, and that parting of ways is amicable. How you will continue to work together in future, if you would like to work, how that can be retained despite parting of ways, because even in our experience, parting of ways sometimes tends to be a little problematic because the thought processes differ. However, I must say that facilitators today are very matured, and the manner in which parting of ways is happening is very well done. But we have also seen cases where, the vehicle was not correctly identified. The intentions were very different of the incoming company, who possibly did not understand the legal implications as they should have understood had they done this study before coming into India and before getting into this kind of a joint venture arrangement. So this is, I would like to clarify here that the purpose of highlighting at this stage itself what are the structures that can be adopted is to showcase the importance of how you enter into the country. If your intention is, if you have the bandwidth, you have the plan which is very clearly drawn up, and you in the interim measures and setting up in an interim manner is not of great concern, then wholly owned subsidiary is what many companies are choosing, and they are preferring to go in that route with, in some cases, facilitators working with this wholly owned company or other wholly owned subsidiary to give the support externally as is required to make this wholly owned subsidiary self-sufficient in times to come, to take their own operations forward, which could be payroll, which could be HR, which could be the facility, which could be the real estate involved, which could be accounting, multiple things that are needed, and of course the most important, talent acquisition. So many companies are doing that, but there are equally or more companies who are looking at the joint venture route, and this joint venture route gives a lot of flexibility in operations also. So this tends to be a preferred way of coming forward, where you start with a facilitator who then you form an entity with them, and then you grow from there, scale from there. But then the important part becomes, what is your structure going to be, which we will touch upon later. Now moving forward, is the screen visible to you? Hi, am I audible?
Yes, screen is also visible. It's perfect.
Okay.
Yeah,
sorry, we faced some technical issues at our end.
So no, it's fine. Thank you so much. Thank you.
Yeah, now what happens, just to give you an understanding, whether it's a wholly owned subsidiary or whether it is an entity formed under the JV route, in any event, there are local compliances and certain central compliances which have to be met with by the resultant entity which is created in the country as a result of your entry into the country. These I put on screen some of the compliances. These are with respect to your registration under shops and establishment, and professional tax registration, EPF, GST, multiple other requirements are there. But the most important that I wanted to highlight was, which is not on your screen, there's the requirement to be compliant with FEMA, the requirement to be compliant with all the existing RBI norms, etc., that would be applicable to an inbound investment that is coming into the country, whether it be the JV route, whether it be the wholly owned subsidiary route. Compliances as per the central laws and with the local laws or other regulators is very important. Now, from a central perspective, it is about your FEMA, RBI, other things that come into play. But locally, you'll have labor law requirements. You'll have, because you'll have real estate in a certain state, the requirements that are there will also be required. Your registration with the department, with the registration department, etc. When you take your premises, whether you're taking, whether you're acquiring, whether you're taking on lease. Now, this will bring me to another point which I will touch upon later. But real estate becomes a very important component of the entire GCC strategy into the country as well. Whether you're going to own the real estate, whether you're going to rent it, whether you're coming through a facilitator, if it's a joint venture model, are you going to be placed in their premises? If you're going to be placed in their premises, how is the branding going to be done? How are you going to later, when you move out of their premises, what are the restrictions that will be there with you? Can you continue with these premises as a temporary space till such time that you get your own space? Because it will be the JV entity, which if it's a wholly owned subsidiary, no problem, that space will be yours. But if it's a JV entry or a JV entity, then how are you going to position that JV entity when it comes to getting additional premises? What is the flexibility you have? Suppose you scale much faster than what you had intended and you feel you need better space, and then you want to have that say in having your space. Then how are you going to navigate your terms and conditions in the JV agreement and the resultant entity? Who will take the calls there? There are so many aspects that need to be looked at. So while regulatory compliances is one part, which of course the facilitator will ensure in the initial days, that is, if you have a facilitator, if you don't have a facilitator, it's a wholly owned subsidiary, there are lawyers, there are consultants, you have all the big names there who can assist the wholly owned subsidiary into making sure that they are completely compliant with the regulatory and the tax laws and the local laws, whatever is required from a labor perspective, central laws from a FEMA perspective. But all these things have to be, the FEMA part of it, the RBI part of it has to be thought through even before you come into the country. So all these things need to be understood. And when it's a wholly owned subsidiary, it's your own captive, it's your own wholly owned. So you tend to be more flexible in how you're going to take it forward. When it is with a facilitator, that is the time when you have to really look at the short term and the long term. And the long term has to be thought through with the short term. It cannot be short term today and long term tomorrow. And that the contract that you factor in today has to envisage the long term today itself. Therefore, all these pieces, your real estate, your labor, what if your headcounts go beyond a certain number? What if your payroll services, how do you want to handle your payroll services once you transition into your own, center? Then are you still going to continue with the facilitator? All those things need to be thought through and put in your JV agreement itself. And whatever the entity that you make, the charter documents of those entities need to reflect all that. This brings me to the next point that I would like to highlight to you, that the paperwork that needs to be done, the documentation that needs to be done when you are getting into these entities and into the relationships as a result of your coming into the country. Now, what is the documentation? So if it's just a service agreement model, that is very self-explanatory, can be understood very clearly only by use of the word nomenclature service agreement model, where there's a master service agreement. Usually when it is a wholly owned subsidiary, there is a master service agreement with another service provider, or the MNC itself is owning the company, and there is no problem with that. With those service agreements, you tend to take it forward and you proceed with your services. Could be the internal in-house services required, deliverables related services required, secondment of people into your organization till such time that you have your own HR. All those things, your employees, how you're going to get your employees, all those things are addressed through service level agreements. They have to be at arm's length. You have to keep all your taxation related issues in mind. The GST, etc., needs to be worked out, and largely this is a fairly straightforward and simple arrangement. The challenge comes in this is when
I think again she got disconnected.
Yes, I'm just waiting if she will come back, maybe.
moment. Yeah, so we will come to the next. We were talking about, the service agreement model. I hope that is where you lost me. Is that where you lost me?
Yes, right.
Yeah. So now the service agreement model, we are having some technical issue which was, not foreseen at our end.
No problem, no problem. That's fine.
So that the service agreement model, where does the complication arise? It's a fairly straightforward model. You get into your service agreements, the entity, the wholly owned entity, subsidiary, or any other entity is serviced through the service agreements. Problem comes when the intention in the service agreement is, while services are being performed today, the intention is that they will translate into a permanent sort of a solution later. Like, for example, I will just give you an example. where you have employees who have been who are carrying out your work. You have gotten into an outsourcing arrangement, and the employees are carrying out a certain piece of work for you. But the intention is that after a year or so, you will absorb all those employees. Now, this is where the challenge comes. Our Indian laws don't talk about transitioning automatically from a company into another company. There will be termination, or there will have to be resignation, and then they will have to voluntarily come and join your organization. That entire process has to be followed. Now, the problem is this process is not rightly explained at the time when these relationships are taking place. So many times companies just feel that, okay, right now they are with the service provider, later we will absorb them. But the word absorb is very, very broad. Does the law allow you to simply say, it's not an asset that you can buy. They will have to go through that process of terminating or resigning and then coming. Now that tends to be a little difficult because the employees have not understood this. And when they start working for you, it's an arrangement that is between your service provider and you, but the employees are not aware of it. So when the time comes to absorb them in the way that is desired, then they have to be intimated that this whole process will be followed. And then many issues come up. For example, what happens to their, whatever statutory payouts that are there? What happens to gratuity, for example, because that is dependent on the continuity of service. So many issues like these come into play. So whenever an entity is negotiating these service agreements, then that entity has to look at all these aspects also. And this is where my understanding and our experience has been that there is a big gap in understanding. And which is why the importance at the beginning itself, when you are getting into your service level agreements, or you're getting into your joint venture agreements and deciding what the future course of action will be, please take all these into account. And I would say educate yourself from the experiences which your consultants have had in such dealings, and ensure that these are all covered or at least conceptualized and discussed and recorded somewhere when the understanding between the two partners is taking place. Now, moving forward, this was one of the examples I gave you. Now, from a JV agreement, for example, from a structure perspective, if you have an LLP, now if you, as I touched upon earlier, that LLP Act has its own provisions. Some continuing obligations may be there. What are the requirements of designated partners? What are the inherent rights that designated partners have, irrespective of what your contract says? Because contract cannot curtail the statute. So many times what happens, you enter into certain clauses believing that this is the understanding between the parties, but the law may not support it. And then later you are stuck with it when the time comes to ensure that this plays out well. Going to a company, in a JV company, if what is the stake you have given to the other side? Is the other side a minority shareholder? What are the rights that are coming to that minority shareholder as a result of being a minority shareholder, which are available to that party under the Companies Act and can be enforced by that party? Could be just stopping any of your major decisions. So, the veto powers, where is the affirmative voting required? How much right to be given to a facilitator with respect to the affirmative voting, etc. All those things should be thought through when you are getting into your arrangement with the facilitator or with any other parties. If they are not getting into a stake, then what is your later evolution of relationship going to be like? And how are your documents and agreements today capturing it? Do you need to have a master service agreement that captures the entire umbrella understanding, and then you have service level agreements with respect to each and every head of the service that you're going to take? Should you, and if the other party is going to have a stake with you, what is the stake going to be like? What is it that you're going to offer? What are they offering for the stake? What is it that you have to give them when they are exiting? Do you have to pay them out? What is the valuation that they will have, and how can they give that up? Many of these things need to be understood. Therefore, the entry obligation becomes very important as far as the GCC is concerned. The entry structuring, the obligations that you carry when you are choosing your facilitator, all these become very important. Now, coming to the next bucket of compliances. So when you are deciding on which entity you're going to go with, you have SEZ compliances, you have tax compliances, you have statutory approvals, data protection provisions, intellectual property right, governing law, termination rights. Now, I will go one by one, just quickly touch upon them. SEZ compliance, there are zero-rated taxes there. There are benefits by being in an SEZ. But then you have to understand very well how you're going to get the SEZ permission. You as a unit in the SEZ, who's going to facilitate that? Is the facilitator going to facilitate that? Is the entity going to continue post the exit? If the entity is not going to continue post the exit, then how will you get the SEZ benefits going forward? If you're going to make a new entity later, are you going to be at a disadvantage for not, all those things need to be understood when you are looking at SEZ operations and compliance. Tax compliance, of course, GST, etc. You have to look at all those compliances. The intention usually of companies coming into India and forming their own centers is that if they are using a facilitator, they expect that the facilitator is going to be compliant. But please bear in mind, you may just be a partner, you may just be a director, but the liabilities of all these compliances will be with you. You cannot curtail your liabilities. Therefore, you must fully understand that even if it's a facilitator who's bringing you in, what are the liabilities you are carrying by virtue of being a partner in those operations? Whether you may be a designated partner, you may in an LLP, or you may be a director in a company. What are the requirements? Are you flouting on those requirements? There should be constant checks, or your involvement in so far as ensuring compliance, or having your own independent consultants giving you support with respect to compliance every now and then is a good idea to ensure that you don't carry any liabilities. Statutory liabilities will continue to be applicable on you by virtue of you becoming director, or whatever the liabilities could be under tax, could be under Companies Act, could be under LLP Act, all those will continue. So all those have to be considered, and then the decision be taken according to your structuring. Statutory, I have already spoken of. You have to, and FCPA is a big concern. Likewise, in other jurisdictions, there are concerns with respect to compliances when it comes to corrupt practices and other things as well. You have to ensure that all those are well signed off. Data protection provisions, we are aware GDPR and many other data protection laws are in place across the globe. How you're going to implement them in India? Our laws are also evolving, though may have differing provisions to some extent. But how are you going to implement those with the services that are being provided, which may well come within the jurisdiction of all those, or are the purview of all those acts, even though those services are being given from India? How the data is going to be stored, all those issues that need to be complied with, you need to look at all that while you're doing your agreements itself. IP, whatever IP is created while you are in the JV, and how that is going to transition. Is there going to be a payout for when the facilitator is leaving? Then what happens to the IP? What kind of contractual restrictions have to be in place when the facilitator is leaving? All those need to be looked at. Then comes the governing law and jurisdiction. This is very important, perhaps not given as much importance as it should be given. So many times what happens is there are agreements, joint venture agreements, where as a result of which an entity is created. However, there are multiple other agreements which may be between the parent company of the facilitator in another jurisdiction. And then there are multiple understandings outside India in various jurisdictions between the company that is coming into the country and the facilitator having a company outside, or could be the Indian company has multiple agreements, internal agreements. So when all these holistic agreements are there, how is the dispute resolution going to happen? Cross default, how is it linked? What happens if there is a breach of any of the major provisions in your major MSA that may be there outside the jurisdiction of India. How is that going to affect the joint venture operations? How do you have a cross default linking the two? What is the governing law? Have you utilized the correct dispute resolution mechanisms? Mediation is something which is really used fully these days globally, and you may have a contract that says mediation, but here it says arbitration after giving notice right away. So now you are in two different jurisdictions talking two different dispute resolution language, and now you are not aware how to go about it, because the timelines differ. So as a result of the mediation happening under another provision in another agreement, you are supposed to set off a timeline, give a notice immediately on default in another in your Indian agreement, but there you are still doing mediation. Now this creates a complete confusion and can be actually quite devastating for the entire issue at hand. And therefore your documents have to be looked at very holistically, where the dispute resolution will happen, what triggers what, how disputes will impact one another, the cross defaults, the consequences of defaults, cross defaults. All these need to be considered, and this I feel is something where I have seen a lot of companies go wrong, where we are reading one document and we realize, oh, this has not been adequately reflected in another document. You must understand these are all players across the globe, and then the actual ultimate the required entities being set up in India. Now, Indian law in certain instances will prevail. For example, if it's an immovable property related dispute, the Indian law will prevail. But if you have another jurisdiction talking about something else, it may be counterproductive, and you may end up defeating your own purpose when you are doing these contracts. Therefore, it becomes very important to be very clear on what you are doing. Transfer pricing is another very important aspect, and how you are addressing transfer pricing, especially interstate services. How are they being, how the contracts are talking about them, and what is being done to ensure that, tomorrow you are compliant, not just with the local laws, but even international laws with respect to, or rather, international understanding with respect to transfer pricing. So these are the kind of issues that need to be looked at, and concurrent understanding of agreements has to be done before you can actually agree. Many times what happens is, two parties have met in another jurisdiction, come to an understanding, done a high-level agreement there, and then after that things start evolving, and then thought processes keep changing, and the agreements that are coming as a result of that also keep changing. And what happens is the first starting document and the last agreed JV entity document will differ in understanding. And therefore, there will be issues. So you have to be very mindful of that. Last but not the least, the termination rights. Now, we are talking about termination rights largely for a JV model. Now, JV model, why is it important, the termination rights? Because if it was a wholly owned subsidiary, this would not be such an issue. You terminate the service level agreement, the service agreements that you have according to the terms of the service agreements. Yes, there may be bottlenecks with you, taking over certain aspects, like I highlighted about employees. You may have to look at it from a tax perspective also. If there's a business, if you're going to do an asset purchase or something, then how are you going to structure that? If it's if you're doing a business buyout of another of the service provider, that also, you have to look at it from a tax perspective, and of course the various aspects of documentation required for that. But by and large, that is fairly straightforward. So termination issues are not so significant when it comes to terminating your agreements as such, your service agreements. But when it's a joint venture model, now it is a structure you have created. It's a real, it's a legal structure that is in place already. And now the party which is with you has got some statutory rights into that structure. Now, when you're going to terminate, you have to, this termination is not done on today. This termination has to be thought of the day you make this structure. So that is where, in fact, a lot of thinking is not done, because when we start typically these transactions, then everything is hunky-dory. Everyone's in good spirits. Everyone's just wanting to get the whole thing done and move on with the business. But many times, you need to think these things through as well, though I must give full credit to facilitators. They are very seasoned and mature, and they are bringing all this up to the parties initially itself, and these are forming a part of your documentation. It is mostly well covered, but there are certain pitfalls which we have seen in our experience, and they can be, how is the exit going to happen? What are the transition mechanisms that you have put in place? How soon does the transition mechanism start before the actual exit? How do you, when you are, is there a payout involved? What is the manner in which you are assessing the payout? Is it linked to the services, the quality of services given? Is there a upside that is given to the facilitator when they are moving out? That will also depend on their contribution in the company, or how they have, what your commercial understanding is, that if they continue for so many years, bring it to a certain milestone, then there will be an upside. Many things come up like these. Then what happens when the exit actually happens? If you're working out of their space, if it is a shared space, how are you going to transition into a bigger space? If it is not a shared space, how are you going to get relocated? What are the support that they will continue to give you, even after you have parted ways, or you are in the process of parting ways? What are the compliances that are required? For example, if the facilitator has been managing the show, then they have possibly got all their names across all your compliances. How are you going to transition that? Because there's paperwork involved. The other side has to sign it off. The board has to agree. Many things are there which need to be done. So this is an intense exercise in itself, which needs to be done very carefully, so that there is no dependency on any party later. Once the parting of ways has happened, after that, there should be no dependency on any party. Because what happens while, if you have chosen the right partner, you will not face any issues. But if there is anything where, the partner that you have chosen is immature or not of the same seasoned understanding as the market requires that partner to be, then issues can come up at that stage. Therefore, all these issues have to be thought through in the very beginning itself. Now, coming to tax, of course, there are many judgments. If you have the right consultant, you will get the support with respect to taxation. The legal challenges I just wanted to highlight is, the labor laws are changing. There will be constant updating happening. They are being made effective in bits and pieces, but you should be aware of what changes are coming in. Be prepared for what changes are coming in. Are you ready for those changes? If you're working with a facilitator right now, has the facilitator thought through all that? I have worked with a wide range of facilitators, very seasoned facilitators who are very in the know of things. At the same time, I have worked with very, very immature facilitators, which have really got the foreign investor into big trouble because they have not been compliant with the law, and they have just done things ad hoc, past board minutes, meetings, because it's just two directors to begin with, and one of them being the Indian director, they tend to be very not so cautious. They work in that spirit where they'll manage when the time comes. So it's a very wide range of facilitators I have seen, and therefore my advice always is be compliant with the law. If you need to have your own consultant looking into things occasionally, like a little mini diligence, it's always good to have that. Human resource, how are something as basic as, if you're in a joint venture, how are the engagement letters structured? What is the flexibility that you have? What is the understanding with the employee? Tomorrow, if you were to, while the exit is there, suppose there is a dispute and you have to close down this entity, whichever you have formed as a JV, then the employee should know that, yes, they will be able to come to your new entity. How is that communication being kept with the employees? What is the interface with the employees? Who is the interface with the employees? These are very practical issues and legal issues, but they need to be kept in mind. How you're going to deal with these as and when the transition happens. Data protection laws, international trade regulations, these are very self-explanatory, as I told you, that all these have to be kept in mind. These are some of the initiatives that are already there for GCCs by the various state governments. Intention is not to go through them. We don't have time now. I would like to open for questions. But just to let you know that the governments are very, very supportive, and they are trying to get as many GCCs to open shop in their states. In Telangana government, the Telangana is again a very prime destination. Many things have been done, and I'm sure many things will be done going forward. And the manner in which permissions are given, the one-stop shop, the one window, the TSI pass, many things exist which make it feasible for a GCC to come in seamlessly and function in the state of Telangana. And of course, the union government efforts are there to make the country, very industry friendly and investment friendly. And in fact, moving to trust-based governance is a very big thing, and ensuring that tax-related litigations are kept low. So there are two things. One is, of course, your interface with the government, and second is the contractual obligations you have with the private party. So if both these things can be handled very carefully, then your entry into the country will be very seamless, and the transition into your own operations will be very seamless. So with that, I would, end my presentation and would request if there are any questions, those questions can be put forward.
Yeah, sure.
Please, once again, for the
technical. Thank you so much, Purnima, for such an elaborative presentation. So much information, actually.
Yeah, in fact, you brought the things that the most difficult topic very really. You explained it very well, in fact. Very impressive.
So my request to the members who have raised their hands, if you can kindly put your questions in the chat box or Q&A, it will be easy for me to read out. One question is, are there any state-specific benefits for GCC?
Yeah, so we have, if you see our last slide, which I have now, removed, but there are benefits that are given by various, so I put up Karnataka and Telangana. There are benefits, and those benefits are there in the policies. You can see those policies. There are benefits being given to any entity, and there are thresholds also if it's a mega project, things like that. So, whatever is there in the policy will be available to any entity which is opening up and which falls within that threshold or within those requirements. Therefore, the benefits are there, and I would encourage you to see the policies of these state governments.
Thank you. Next question is, can you explain more on income tax related aspect for a GCC at inception and transfer of equity stake?
So transfer of equity stake, I spoke to at length. We are not income tax experts, so I will not delve into too much of taxation, but I would definitely say when you are at the entry, and that was something I spoke of earlier, please see vis-a-vis both the structure that you apply, you adopt, which is more tax efficient. So you look at it from a company perspective, your LLP perspective. Earlier LLP had this big advantage of there being no dividend distribution tax. Look at it from a company perspective. What is the tax implication? What is the capital gains tax that you could look out in vis-a-vis your planning of exit? Suppose you are planning to exit the entity later in time. What are the type of tax implications you would have? Keeping all that in mind, I think with the right taxation advice, you can decide on the structure that you're looking at. Also, please bear in mind transfer pricing and all service agreements that you get into. What are the GST related? So income tax is one part of it. Your capital gains, etc. You look at all that, but also look at your GST, etc. How you're going to, and then factor in what is the best model for you.
Okay, thank you. Next question is LLP versus LLC, which is beneficial from IT perspective? So
LLC, now LLP is what we have in India.
Yeah, I know.
And so, not necessarily what we have in the US can be replicated here. You have to go by the laws here. And LLP is the model that is accepted in India. Yeah, we don't have the corporation model in India.
Yeah, because that is not Indian model. Where again,
But maybe the question is LLP versus a company. If that is the question, then I have already explained to you that you have to look at your long-term objectives, your short-term objectives, whether you're going to transition from short-term to long-term. Will this entity suffice your requirements when you do that transition? Whether you will have to make your own entity later. Well, will that have a regulatory impact? Will that impact your SEZ presence if there is one? All those things you have to keep in mind and then choose what is the right entity that you should have.
Can you please let us know about the existing support system available for facilitators?
Support system from a state perspective, if you're asking, then I will, okay, you're talking about support system of facilitators. There are many facilitators in the market today. And you have a wide range. You have from, very, very matured, having a strong global presence, to very, very, who are helping very seed level companies also. So you have all kinds of facilitators. There is a big segment, but even the government is trying to support, where you have, say, for example, the T-hubs and all, where all full round innovation support is given. So, there is a big ecosystem now which is available to help.
Also, if members would like to ask any specific question, we will share the email ID of Purnima Garu, and if they like to send any question with a copy to me, or you can send to me and I can forward. So after this session, if you feel like asking something, you can email that. Our next question is, apologies for little deviation. I wanted to know the best way to be legally secure while appointing an agent for a certification body like US FDA and setting up a consumer network in a foreign country. I think this is not related. My request is, if you can, we will share the details of the speaker, Purnima Garu, and if you like, you can send an email to her. And if her time will allow, and she can contact you or answer that email, maybe that is the best way. We'll not waste time for this session. I think questions. Will you share the slide later? I don't know. Purnimaji, can we share the PPT later, or?
I don't think we'll be able to share the PPT. That was only for the purpose of this webinar.
Yeah, so I think we'll not be able to share the PPT with you, but we can share the recording link of this session and also the details of the Purnima Garu, her email ID. And if you like to send any question to her, maybe you can contact. So thank you so much, Purnimaji, for answering very patiently all the questions, such a detailed presentation and so much information for the members. And this was actually a very important topic. Our chairman, Ganesh sir, is also here.
Yeah, thanks, Purnima-ji. Really appreciating the way you explained the things. Thank you.
I'm glad. I hope this was of some value, and anything anybody can reach out.
Oh,
and thank you so much for giving me the opportunity.
Oh, it's our pleasure. In fact, we'll share the email address of Purnima Garu. The members can directly approach her.
Yeah, I'll share the number of the office, and if anybody would like to reach, and they can write to me, or they can directly write to Purnimaji for the this thing. And thank you so much, Purnimaji, once again, and thank you, Ganesh sir, for your time and presence. Thank you, one and all. We will conclude this session.
Thank you, Shikha. Thank you, Ganeshi. Thank you, attendees. Bye-bye.
Thank you so much.